incomplete justice, question mark. The Supreme Court at 75 reflects on the court's journey through law, practice, and lived experience. We are honored to join by Justice S. Muralidhar, editor of Incomplete Justice, the Supreme Court at 75. He enrolled as an advocate in Chennai in 1984. He later practiced in Delhi and served as an advocate on record in the Supreme Court of India. He was elevated as a judge of the Delhi High Court in 2006 and served as Chief Justice of the High Court of Orissa from 2021 until his retirement in 2023. He is also the author of Law, Poverty and Legal Aid, Access to Criminal Justice, and was designated a senior advocate by the Supreme Court in October 2023. With him in conversation is Anup Surendranath, Professor of Law at Nalsar University of Hyderabad, and co-founder of Executive Director of the Square Circle Clinic, a criminal justice initiative providing pro bono legal representation to the death row prisoners and under trials across India. The clinic's work has led to numerous acquittals and commutations and has received national and international recognition. Over to you, Anup. Request people, to maintain silence because there's a lot of, voices that are getting carried away and disturbing people in the back. So please be quiet.
Good evening, everyone, and thank you for having us here today. And it's a pleasure to be with Justice Muralidhar with such fantastic experience across the bar and the bench, and one of the most outspoken critics of what is happening in India's legal system. So you can expect a very frank and fair conversation today. So to kick things off, before we get into a conversation, I'd request Justice Muralidhar just to take about 10 minutes to introduce the book and the various perspectives that are coming through the book, and then we'll move to a conversation for about 30 minutes after that, and then 10 minutes of audience Q&A. Justice Muralidhar, over to you.
Thank you, Anup. Thank you, Anup. It's a wonderful audience here. Good evening, everyone. One of the questions I'm often asked is about the title to the book. Why is it called Incomplete Justice? Some of you have a copy in your hands. So the word incomplete is a take on an expression in one of the provisions of the Constitution of India, which is Article 142 of the Constitution. For those who may not be conversant with that, it says that in order to do complete justice, the Supreme Court can pass orders that it thinks fit. Basically, it gives a free hand to the Supreme Court to mold reliefs in cases. One of the most common examples for a lay audience would be a breakdown of a marriage, an irretrievable breakdown of a marriage, because two partners find themselves incompatible for a variety of reasons. Now, this is not one of the stated grounds for divorce under the Hindu Marriage Act. So the Supreme Court has, using this power under Article 142, dissolved a large number of marriages where both parties have said, we just can't coexist anymore as partners, as spouses. This is just one example. The other example, again related to matrimonial matters, is quashing of criminal cases which are otherwise non-compoundable. Typically, a Section 498A, cruelty during marriage, is something which is not compoundable if you went before a criminal court. But the Supreme Court uses its powers under Article 142 to do that. And it also says now the high courts can do it. So there are a large number of things that the Supreme Court does for what it considers to be doing complete justice. But the book is called Incomplete Justice because there are a large number of issues for which people come to the court, for which they do not get complete justice at all. There are many cases which don't get acknowledged, the cases that do get acknowledged do not meet their logical end. And after several years of litigation, and as a judge who's been on the bench for about 17 and a half years, I've often noticed both parties walking away dissatisfied. Both the person succeeding in the case and the person losing the case, both have a sense of dissatisfaction. Of course, the person winning has some degree of satisfaction, but not complete satisfaction. So the title Incomplete Justice is also about what litigants feel within the system. We've put a question mark because there can be different perspectives on this. And we've also put a bracket around the word in, because people may think, given all the circumstances under which the court functions, too many cases, too few judges, and all the attendant problems of how the law works, how it works unequally, some people might feel that the court cannot possibly be expected to do better. So this is as far as the title to the book is concerned. But what distinguishes this, and what we hope distinguishes it from other similar volumes commemorating 75 years of the Supreme Court, is the expression critical reflections. What we find is whenever an institution brings out a publication at the end of 10 years, 20 years, 50 years, it largely tends to be self-congratulatory. It kind of glosses over the institution's weaknesses, the institution's failures. We wanted this volume to make people introspective, including the judges who man these institutions themselves. We want voices to tell the judges that this is where the system failed, which is where the courts failed, this is where the justice system failed people, and to be aware that there's so much more to do to make it work. So Critical Reflections, therefore, invites its own set of authors. And the authors were chosen because here is a set of people who are generally known to be fearless, not afraid of being critical of the functioning of institutions. I want to draw a distinction between the word criticism and critique. So many of these pieces are a proper, well-informed critique of the working of the system. And even if it sounds to be criticism, it's meant to be constructive. The other thing about this book is this, that we've tried in a kind of way to bring in the voices of people who are not associated directly with the legal system. That is, people who are neither lawyers nor judges, and perhaps not litigants. Maybe some of them are. So we've got 6 of India's most eminent cartoonists to give us 17 cartoons. So right from the introduction through the end of the book, you will find 17 cartoons where these artists are telling us how they see the system. And that's very important for, I think, anyone within the system and being associated with the system needs to know. We also have among the authors, which includes judges, academics, lawyers. We also have one non-lawyer, Mr. Sainath. He's a veteran journalist. And he's written about the Supreme Court and the countryside. And my favorite piece is Sainath's piece, because it opens with this conversation that he's having with a villager in Bharatpur in Rajasthan, where the Kumbher massacre took place in 1991. And that villager tells him, you may have your courts, you may have your Supreme Court, but for us, our local Thanedar decides what should happen and what cannot happen. So how the ground reality is so different from what the Supreme Court imagines it to be. So Sainath wonders, does the Supreme Court actually understand the countryside? And this is a question many of us have asked, having been in the system, that there are many issues, many people whom we don't even notice, whose problems we don't even acknowledge. And even when these problems travel up to the court, we don't quite resolve them in the way it should be resolved. One of the cases concerns, which is discussed in Sainath's piece, concerns prescribing qualifications for sarpanchas in the elections to the Panchayati Raj institutions. One of the disqualifications is having more than 2 children. Another disqualification is not having studied beyond the 12th standard. And the persons who are suffering most because of this kind of a set of conditions are the women themselves. Unfortunately, the Supreme Court upholds this kind of a rule, And that's critically commented upon, and I think rightly, by Sainath. The book doesn't cover a large number of issues because it has a word limit. No piece could go beyond 8,000 words. And the book itself couldn't have gone beyond 600 pages. These were the constraints that most publishers tell you that they have to work within. So I've got a set of 4 interviews. An interview with Professor Upendra Bakshi on social action litigation. Professor Bakshi insists that he will not call it public interest litigation, but social action litigation, and gives us I think, a fairly convincing explanation of why he does that. I have an interview with Indira Jaisingh, one of our foremost legal practitioners, and as a woman, one of the earliest to be designated as a senior advocate by the Bombay High Court, and who still continues to be a very, very critical voice within the system, and who's done a lot to promote gender justice, who's done a lot in the terms of legal services movement, and who runs a very, very well-read legal journal. Earlier it was called the Lawyers Collective Journal, and now it's the Leaflet. And she brings to bear almost 6 decades of law practice, experience of law practice. Then I have an interview with Meenakshi Arora, a senior lawyer in the Supreme Court, on how the legal profession works. In fact, most of these books that we have of the Supreme Court and of the way the court system works do not really touch upon the way lawyers function. And they are a very, very important component of the way courts work. In fact, all the research, the reports that we have on the functioning of courts seldom mention the role of lawyers. And we don't really get proper empirical inputs on what lawyers do. So we have a whole section in this book on what the lawyers are doing within the justice system, either to make it work or to not make it work. The last of the interviews is with Sriram Panchu. And Panchu is one of the pioneers of the mediation movement in the country. And he's also watched the way the system works very closely. So he reflects on a large number of issues concerning lawyers, courts, alternative dispute resolution practices, including mediation. We have 3 foremost criminal law practitioners, Vrinda Grover, Rebecca John, and Nitya Ramakrishnan, give us 3 chapters on the entire working of the criminal justice system. And we have critical reflections on individual topics in the law by Justice Chandru, Justice Gautam Patel on environment, Gautam Bhatia on media freedom, Suhrit Pasadi on the 10th schedule, and so on and so forth. We have some of our eminent judges, Justice A.P. Shah, Justice Madan Lokur, Justice Ravindra Bhatt, give us chapters on the way the judiciary is worked. We have Usha Ramanathan, who reflects on judicial delays and what delays do to defeat justice. So we have a range of issues that are covered in the book. We have pieces by Professor Mohan Gopal on how the Supreme Court has understood caste. And it's a definitely provocative piece. It's meant to get up to notice that the way the court itself understands caste and religion could be a very colored vision that it has. And we need people like Mohan Gopal to tell us that. So we really have a good range. Professor Faizan Mustafa talks to us about Article 30, minority educational institutions, and how the Supreme Court has played a central role in that. I may be missing out. Rohan Alva talks about constitutional amendments, constitutional benches, and the way the constitutional benches have functioned over the years. So there is a whole range of issues we've sought to cover, but we still haven't covered many other issues. So this is not meant to be a complete comprehensive review of everything the Supreme Court has done. For instance, this Article 142 itself requires a special treatment. I would think it's a parallel constitution by itself. If you really start discussing Article 142, maybe have a 7-volume series for all you know. I haven't discussed contempt of court. This is an issue that media professionals face, many people who are critical of the court system face, and we haven't been able to devote a chapter to that because of time constraints, word limit constraints, and so on and so forth. But yet, this has been a very satisfactory exercise. I just want to end saying that none of the authors, and definitely not me, are people who believe that what we have said can't be disagreed with. We are very conscious that we are only provoking discussion and debate. And this is for people to agree and disagree with. But if you're able to disagree, it's a healthy sign in a democracy. We want different points of view to emerge. The entire book is to ignite discussion and debate. If it can be an informed one, the better for the nature of the debate. But we are at a very critical phase in our court's history, in the judiciary's history, where new challenges are coming forth. But there is also hope. Because of the change, marked change in the legal educational system, which Professor Kamala Shankaran is writing about in this book, we have the national law schools. We have a crop of law graduates emerge. Anup is himself a stellar example of that. Many of them, earlier, of course, were going to corporate law firms. They still do. But a sizable number, I would say a critical number, has come back into litigation. And a critical number has come back into academics. And this is a very healthy sign. Being a judge, I can tell you, the quality of submissions made in the court is improving. Some of them have worked and are working with judges and law researchers. They're helping improve the quality of the judgments. So these changes are very visible. Project 39A is one wonderful experiment which is continuing now as Square Circle, where very young lawyers with a great deal of commitment have gone into prisons, unearthed stories of prisoners on death row, and actually brought back their cases to the court for doing complete justice. So these kinds of movements within the legal sphere gives me hope that it's not a bleak future we are looking at, but it's definitely a very challenging future we're looking at. This institution is critical for every one of us sitting here and for every one of us in the country. Law affects various facets of our functioning. The court has become a very critical player in that. Thanks to live streaming of court proceedings, hybrid hearings, online journals on law like Bar and Bench, Live Law, there is far more discussion about courts, the court system, about lawyers, which is all healthy, and which is making that attempt to democratize the institution. I wouldn't say it's a perfectly democratic institution. This is one of the challenges the judiciary faces. But I think with all these provocations, and this book is definitely meant to be one such provocation, we should all make this institution work better for the people of India. So with those comments, I hand it over back to Anup. Thank you.
Thank you, Justice Muralidhar, for giving us an overview of what the book was trying to do. When the court completed 50 years, there was a publication called Supreme But Not Infallible, right? And in that spirit, this conversation will be carried out, that the Supreme Court might be supreme, but it is certainly not infallible. And there's always concerns with what the court is doing. And in this juncture, where our democracy is the Supreme Court as the guardian of the Constitution has much to do, and it is very important that we assess the court's functioning as concerned citizens, right? So I want to ask my first question, Justice Muralidhar, from the essays by Sainath on how the Supreme Court responded to the farm laws, how it responds to caste massacres, and Professor Mohan Gopal's own understanding of how the Supreme Court really misunderstands caste in India, and Ms. Jaisingh's concerns around the court's engagement with gender. It almost seems that these three essays are making the case that the court struggles to understand the socio-political and cultural milieu in which it is operating, right? And that might much have to do with the composition of the court itself, right? That the court has had about, I would say about 285 judges, of which less than 10 have been Dalits, about 11 have been women, and about 15 or 16 have been Muslims. So in that sense, is the court struggling to come to terms with the complexity of the reality in which it is functioning?
The answer is, of course, yes, but we need to complicate it even more. Within the court, it's what is called polyvocal. So unlike the different apex court bodies in different countries, our court has 34 judges. Our Supreme Court has 34 judges sitting in at least 15 to 16 benches. And when I mean benches, which is a panel of 2 judges, sometimes 3 judges. The rate at which these benches of Supreme Court are disagreeing with each other has really shown a remarkable increase. And within a very, very short while, either the next bench stays the order of the earlier bench or reverses it. So this is a trend which one is noticing in the last 5 years. So this is something that is reflective of how two people simply are not able to see an issue in the same way. Just to give you a recent example of Aravali Hills. One judge accepted the central government's, nudging to make it define Aravali Hills as something being up to 100 meters and not beyond. And because of this outcry in the media and in social media particularly, as soon as the judge who presided over the bench retired, within a week, that whole judgment was put on hold by the next bench. We've also had instances like the Sabarimala decision, which is a constitutional bench judgment, which had one dissent, which was a majority of 4:1, which said that preventing entry of menstruating women into the Sabarimala shrine is unconstitutional. It hits on their dignity. Within a few months, we had the whole issue elevated to a bench of 7 judges, and one judge being common to both these panels who just changed his mind. Yeah. So we are also having this phenomenon of the court being unsure about where it stands on very, very critical issues. This is for a variety of factors. Of course, you've mentioned one, because the background of the judges, the upbringing, the cultural moorings, the exposure, how you're exposed to issues in the bar. Everybody here should know that every judge who's sitting on the bench, right from the magistrate to the district court, to the high court, to the Supreme Court, has to be a lawyer. So the kind of practice that you've had at the bar informs your understanding of both law and society. Typically, let me give you an example. If you've practiced criminal law in your years as a lawyer, and today you're sitting in the roster in the high court, deciding intellectual property rights, you may not have an exposure at all to those issues, and so it kind of slows down the process and makes it more complicated for the judge and definitely for the lawyers. The converse is actually even more problematic. If you've had no exposure to criminal law, you may have had very little exposure to law and poverty. You may have no exposure to how people live, the ground realities. And that, again, makes it problematic for you when you have to decide bail applications. So the orientation of our judges to constitutional values, to constitutional law issues is something that I have found personally to be wanting. So there is a combination, therefore, of lack of understanding of the socio-cultural milieu, and most of the learning is vicarious. So the way our whole case presentation happens, while at the trial courts, they are likely to hear the voices of the people in first person. As you travel up the system, it's all only through the written document. Yeah. So you only have affidavits, and much is lost in translation. Most of the affidavits are written in English, and many clients are asked by the lawyers to simply sign at a particular spot. It's actually a sworn testimony by the person before the court without realizing that it's supposed to be the voice of that person. And it's the lawyer who drafts it, and you simply sign it, trusting the lawyer to say that everything you wanted to say. So there is another level of problems, therefore, in the way the court understands ground realities. Yeah. So all these issues therefore, do matter. And last is about landlord-tenants, employer-employee. So this social milieu in which judges move, while we like to imagine that judges are completely isolated and are living in some kind of an ivory tower, it's not entirely true. Yeah. Judges do co-mingle with others when it comes to, let's say, attending somebody's wedding or having a farewell function where they meet the lawyers. And even in their own circles, it's very likely judges move within a certain upper crust of the power structure that in our society, and not so commingle with, let's say, laborers, people on the ground like constables, drivers. It's very unlikely that they will move in those circles. That also colors their perception and removes them from reality.
Right. As with the book, there are many issues to traverse, so I'm going to be selective in what I think are very critical issues. There are about 3 essays in the book on judicial appointments and administration of judges. in that context, I want to raise the question of what we are seeing about the connections between the political dispensation of the day and appointment of judges. Obviously, in the very recent past, there have been controversies around appointment of Justice Victoria Gowri, more recently Aarti Sathe. In that sense, also Abhijit Gangopadhyay of the Calcutta High Court joining a political party after finishing his tenure on the bench. In that sense, are you concerned with that dynamic, or do you see it as a part of a larger trend as well? Because even historically, you've had judges dabble in politics in different ways, be it Justice Subbarao or Hidayatullah or H.R. Khanna, or the Congress's own relationship with Justice Baharul Islam, right? So in that sense, is something different happening now, or is it a larger concern over the decades that's nonetheless continuing now?
Let's go back to history. So the very first cabinet that we had, headed by Jawaharlal Nehru, had a question before it when Harilal Kania, the very first Chief Justice, died in office. So the question was, who should succeed Justice Kania? The next in seniority was Justice Patanjali Shastri. So the judges had no doubt, and there were just 8 of them at that point in time, that that seniority principle should be followed. Whereas Nehru wanted Chagla to be brought directly to the Supreme Court. Justice Chagla is one of the most renowned jurists that we've had, who was a Chief Justice of the Bombay High Court for over a decade. And the then Attorney General, Mr. M.C. Setalvad, also supported this move. But the judges said they would all resign en masse if this happened. And that's how the very first supersession was averted. So the need for the executive to somehow control appointments to the judiciary started very, very early. This is something people don't realize. Of course, during Mrs. Gandhi's time, when the Congress fared very badly in the 1967 elections, for a period of 3 years, it had to survive. Post the split in the Congress, Mrs. Gandhi's party was called INCR, which is the requisitionists. And they cobbled together a coalition and barely survived. And because she was not confident of getting measures passed through Parliament, she got ordinances for pushing the privy purses abolition and bank nationalization. Both those moves were, negatived by the Supreme Court. The Supreme Court also came up with this decision in Golaknath, where it said Parliament's power to amend the Constitution can't be to the extent of amending away the fundamental rights. So she was faced with a real challenge between the years 1967 and 1970, where she could do very little to influence appointments to the court, although at that point in time, executive had the primacy in the matter of appointment. 1971 January, she comes back into Parliament with a thumping majority. And one of her trusted cabinet ministers is Mohan Kumar Mangalam. I'm mentioning all this just to say how Krishna Iyer entered the scene. If Mohan Kumar Mangalam had not got the idea of packing the judiciary, which he wanted to execute, we would not have seen Krishna Iyer in the Supreme Court. And today, nobody can argue that that was a bad appointment. In fact, we are very grateful that there was a Krishna Iyer sitting for about 7 years in the Supreme Court of India. So it has its history, the politics informing the appointments to the court. I must just complete that narration. So what she managed with the help of Mohan Kumar Mangalam was to handpick judges to form a bench that would overrule Golaknath. And they actually succeeded in that experiment, because although the basic structure doctrine came in with a wafer-thin majority of 7:6, all the 6 who were in the minority were these handpicked judges, handpicked by Mohan Kumar Mangalam and therefore by Mrs. Gandhi to the Supreme Court. So we've had this. We've had a history of politics, whether in the pre-collegium system or in the collegium system. What has happened is, with the striking down of the National Judicial Appointments Commission amendments, one thought that the collegium system will therefore strengthen itself, because that judgment, while it says independence of judiciary is part of the basic structure, and therefore we will not have a Judicial Appointments Commission where the executive has the primacy, also is introspective to the extent of acknowledging there are serious issues with the collegium system. But the aftermath of the judgment has been very disappointing, where the executive continues to dominate the judicial appointment process. So executives today are able to determine which judges will come to the Supreme Court, which particularly will not. So to answer your question, it's not as if politics was not happening earlier, but actively keeping a certain politics out is more very, very, apparent in the present dispensation. Anybody who's fiercely independent, anybody who can possibly withstand pressures of, interference by the executive, whom they're unsure of because of that, is being kept out, and which is a very unfortunate part. So on the 3 appointments and the 2 instances that you gave of appointing general secretaries of the BJP Mahila Morcha in both Maharashtra and in Tamil Nadu to the high courts, and Justice Ganguly, within a week of his resigning, getting a ticket to the Lok Sabha and actually entering the Lok Sabha on that ticket, on a BJP ticket. These are all more, what I would say, brazen examples of executive interference in the appointments of judiciary. But it is not as if the system doesn't know how to handle this. If they were actually transparent about this and they said, okay, we are taking persons of this political viewpoint, but we're also therefore taking persons of another political viewpoint, fair enough. Then you have a diversity on the bench, but you're not doing that. You're allowing a certain kind of politics to enter. You're keeping out a certain kind of politics. And today in the appointment process itself, although there is a memorandum of procedure, and although the judiciary is supposed to have the last word when it reiterates a name, despite reiteration of names, those names are not getting notified by the central government. And the problem is that the judiciary is not asking questions. It is quietly succumbing to that decision of the central government. And you also have an unofficial vetting process of names. So which is again very, very unfortunate, because we really therefore have made the system more opaque, less transparent, and therefore less accountable.
Justice Muralidhar, one of the most brazen acts of defiance of the Supreme Court was, I would think, what Justice Shekhar Kumar Yadav of the Allahabad High Court said, what the Supreme Court, what was, and I think rightly seen as very worrying hate speech for a judge to say something like that. And when the Supreme Court called him in and said that perhaps what he said was avoidable, Justice Yadav seems to have put his foot down and replied to the Supreme Court that he stands by what he said. And therefore it seems to be, and of course, there is a certain relationship between the High Court and the Supreme Court that also needs to be maintained. But as you said, the word that you use, that brazenness seems to be a growing concern that we're confronting.
See, the dominant executive, earlier, always a dominant executive, a more pliant court. Whether it was Mrs. Gandhi and emergency, when they actually upheld the MISA and all of that. So that is a pattern that we've understood. The troubling thing now is that certain judges know that the executive is backing them. So when you table 2 motions before the speaker, more or less in the same time, you had Yashwant Verma's motion and Shekhar Yadav's motion. Yashwant Verma's motion gets picked up by the speaker, a committee is appointed. Shekhar Yadav's not at all. What is likely to happen, I think Shekhar Yadav retires in a few months, and the whole thing becomes infructuous. So we've had these kind of instances where individual judges somehow seem to know that they have the backing of the political dispensation, that nothing will happen to them. So this is again a troubling phenomena, a very troubling phenomena.
And I think Dr. Ramanathan in her essay, I thought it was a very interesting take on judicial delay, talks about the court's strategy, or not, whatever, the court's practice, or you want to call it a strategy, to decide by not deciding, right? Be it the Aadhaar case, or the demonetization case, or the electoral bonds, or that the abrogation of Article 370 gets decided 4 years after the abrogation, the court's decision on internet shutdowns in Jammu and Kashmir. So all of these seem to be urgent constitutional questions that have a direct impact on liberty and our democracy. And I just want to map that alongside Rohan Alva's essay on how the number of constitution benches, which are 5 judges or more, is seeing a rather sharp decline over the decades, right? So the court seems to be retreating from deciding these questions. And the electoral bonds is such a classic example where the court strikes down electoral bonds, but so much money has been raised and disbursed in the meanwhile from when the scheme was challenged to when the courts come to the conclusion that electoral bonds are unconstitutional. What are we making of this dynamic between the court and the executive on staying back? And the court is not staying any of this while in the interim, while these cases are pending.
So Anup, what you didn't mention is the master of the roster issue. So I deal with this in my introduction. It is the Chief Justice of India who constitutes benches. This is something that we need to understand. It's the Chief Justice of India who understands his judges. So they say how Justice Subbarao was the who's the judge who's dissented the most number of times till the time he was the Chief Justice of India. After Justice Subbarao became a Chief Justice of India, he somehow ensured that there are very few dissents on his bench, which means he understood his court so well that he would bring on to his bench people who would largely agree with him, which is also problematic. So this constitution of the benches in themselves is a power that the Chief Justice wields, and that determines actually, to some extent, the outcome of the case. And therefore, the dissent in demonetization is a single dissent of Justice Nagaratna, which probably they didn't anticipate. But you have no dissent in the Jammu and Kashmir 370 case at all. For instance, you've had benches constituted to decide on the validity of reservations. You have judges who come from the other backward communities. You have judges who belong to the scheduled caste who are not included on that bench. So the diversity on the bench, the plurality of voices that you need, because how constitutive is this bench? How representative it is of different voices? That matters. If you are going to conveniently constitute benches that only of people who agree with you, there is a problem. Second is, which kind of issues will you pick up and when? So you're absolutely right that by not deciding, you decide. So you actually allow them to present you with a fait accompli. One example which you didn't mention and Usha has mentioned is Pegasus. So much has been said about Pegasus. We all know it was planted on the phones of journalists, leaders of the opposition, even judges. The Supreme Court then said, okay, we're constituting a committee. That committee is in fact given a report. The committee has said the central government is not cooperating with us. It's on the back burner. So now you should ask, why did any Chief Justice of India, after Justice Ramana, who constituted that bench, constitute that committee, why did none of the Chief Justices pick up this issue? Money bill, for instance. You pass off the Aadhaar law, the UIDAI law, as a money bill. Anyone will tell you, with bare knowledge of constitutional law, it doesn't qualify to be a money bill at all. But by not deciding that case, and in the meanwhile upholding the validity of the Aadhaar law, and that dissent there is so powerful. This is the point that dissent makes. You haven't decided the issue of money bill and you're deciding the validity of this law. But fait accompli again, the Supreme Court is predetermining the outcome of many of these cases. So I would trace it to the power of the master of the roster. That power needs to be interrogated. People have asked me, does it mean that we also make that power a collegial power? Instead of the Chief Justice himself or herself deciding, should not a senior set of judges decide rosters? But according to me, it's impractical. Having been a Chief Justice myself, it's not practical. It just comes down to this. Whichever system we evolve, if the people exercising power within that system don't hold themselves answerable or accountable, we're going to have a problem.
Yeah. So, Justice Muralidhar, in the interest of time, I have 3 or 4 more questions that we have to quickly get through, right, before we run out of time for the questions. One is your decision in Zahur Ahmed Shah Watali on, when you were in the Delhi High Court on the UAPA bail provision, right? And as many of you might be familiar, it almost says that unless you can show that you're prima facie innocent, you will be denied bail under the UAPA. You gave a very strong judgment saying what are the standards that we must use at that stage, given how problematic that bail provision is, which of course the Supreme Court overturned. And now we see in Gulfisha the court almost saying that you have no option but to buy the narrative of the investigative agencies. Where are we going on the presumption of innocence when we are saying we will keep back people for 6, 7 years in prison without even the trial starting. So even in the recent case denying bail to Umar Khalid, you don't see the court engaging with that question sufficiently. You've kept a guy for 6 or 7 years, and there is no trial anywhere in sight. So what is happening to the presumption of innocence?
So I think this is what we call rule of law. Not rule of law, but rule by law. See, the model of detention has stayed with us in our constitution since 1950, which is a very, very unfortunate aspect. This is in terms an executive detention. So in the law of preventive detention, you avoid the judiciary altogether. And Article 22 of the Constitution legitimizes this kind of an executive detention. But by incorporating very harsh bail provisions in some of these laws, you're mentioning the Unlawful Activities Prevention Act. If you look at the narcotic drugs, that law, and you look at the Prevention of Money Laundering Act, they're all copy-paste. The provisions are actually copy-paste. Basically, shifts the burden of showing that I'm prima facie innocent on the accused, just making it impossible. Because in our criminal justice system, for those who may not be familiar, the accused does not get to lead evidence. The accused is not permitted to bring in materials to prove innocence. The accused, till the stage of the beginning of the trial, has to only go by what the prosecution has placed before the court, which are bound to be materials which is, trying to prove the guilt of the accused. So as it is, it's one hand tied behind your back without these extraordinary laws. What these extraordinary laws do is saying with that one hand tied behind your back, you have to bowl, bat, field, everything with one arm, and you have to win the match, which is impossible. So what we have done in some of these cases, in Vatali also, looked critically at what the prosecution is telling us. Saying if there's an internal inconsistency in the charge sheet itself, a court is bound to look at it. Because how is an accused supposed to demonstrate innocence, or even on a prima facie basis based on those materials? Of course, the Supreme Court disagreed, but later benches of the Supreme Court have found problems with Vatali. They've tried to dilute it. Now, the later judgment, including Najib, which is by a 3-judge bench, is simply distinguished by this 2-judge bench. So it also brings up the problem of judicial indiscipline, where a bench of 2 will simply refuse to be bound by a bench of 3 and say, oh, it's distinguishable, it's in a different set of facts, and therefore I'm not bound to follow. So that's the other problem that people face today. So while bail is the rule and jail is the exception, one of the first cartoons in the book is a wonderful cartoon by, Advaru, where the statue of justice is shown chanting, bail is the rule, jail is the exception, and at some point, the narrative gets inverted.
So just very quickly, I think for all those concerned with the rule of law in this country, why the Supreme Court in Gulfisha's case does not apply Najib, which says that if there is a speedy disposal of the case that is not happening, you will get bail nonetheless, irrespective of what the UAPA is saying, was a 3-judge bench decision. This decision, the most recent was 2-judge. And it is quite shocking to anybody who reads the judgment, as Justice Muralidhar was saying, why they don't apply a decision they are necessarily bound by.
Just to add to that, see, this is a failure of the judicial system in not being able to expedite trials. All these cases, the UAPA cases, go on the presumption that trial will be over within, let's say, 2 years or 3 years. This is far from the truth. Whether it's the Bhima-Koregaon set of cases or these Northeast riots cases, 7 years have passed, we are no longer near trial. So what the court needs to acknowledge is that somebody has spent 7 years as an under trial, and tomorrow that person gets acquitted after a full-fledged trial, which is likely to be 10 years. There is no compensation for the lost years. We don't have a regime of compensating persons for loss of liberty. If they again file a suit claiming compensation, let's say in lakhs or crores, that's going to take them another 20, 25 years. So this reality, which is facing the judges, which they know pretty well about, can't be ignored by them. So you can't say delay in trial is not an issue here. It is very much an issue. So you may have the most draconian law, but if it is not going to, result in an expedited trial, if it's going to be treated just like any other criminal case when it comes to trial, I think there can be no excuse to say, no, let him spend some more years in jail and we'll see later.
Yeah, absolutely. Anyway, I'll stop our conversation here and pick up maybe 3 questions. Please keep the questions very short. Don't want sort of long. One here, the lady at the back, and one, and the gentleman at the back.
Yeah, so I'll also request this. Some of you have strong opinions. So just keep those opinions in check and just straight away fire the question.
The young lady here. Just keep the questions very short, please. Yeah.
Good afternoon, sir.
Good afternoon.
Do you think the Supreme Court has increasingly shifted from being a counter-majoritarian institution to a rather managerial one?
Okay. Yeah, ma'am.
Yes.
Thank you for the short question.
Yeah.
So my question is on the influence of judgment by the public opinion.
Right.
So right now we are in a, it's social media everywhere. So is there, is the judgments being influenced by social media and people opinion,
And public opinion.
more, or
Okay,
it is not being influenced at all?
Thank you. Thank you. Appreciate the short question. The gentleman at the back. Yes, yes, please. And then ma'am. And we'll stop with that. Yes.
Would you suggest some reforms to the court to make, especially in the terms of accessibility and also accountability?
Yes.
Thank you. Ma'am, please.
Yeah, we've seen how the social fabric of our country has been torn apart by corruption, and we feel free, very free to call out corrupt politicians, businessmen, professionals, bureaucrats. But with due respect, sir, if the judiciary was sound and non-corrupt...
Ma'am, the question, please. The question, please.
If that would have been, we could have controlled this. Why is contempt of court such a strong thing in our country?
Okay. So we have less than 4 minutes.
Oh, okay. So counter-majority into managerial. It all depends on the Chief Justice of a given court at a given point in time. There are instances of the court really exercising the counter-majority measure, but it's happening so infrequently that you don't notice it. So I'll just draw your attention to a judgment called Sukanya Shanta versus Union of India. It's about caste in prisons. So it's so strongly counter-majoritarian because this is an elephant in the room, like they say, and it's all around us. And in prisons today in India, you're allocating work among prisoners depending on which caste they belong to, and that has been held to be unconstitutional. So you have this one ray of hope that the court can be counter-majoritarian if it wants to. But you're absolutely right, it's not picking up those opportunities to be counter-majoritarian. This is happening for 2 reasons. One is the courts themselves should believe that that's their primary role. If judges start believing that they have to always bow down to parliamentary wisdom, they should not question executive decisions because of it being informed by some policy, then the judges are limiting their own roles as counter-majoritarian institutions. So your question is absolutely right. Social media has a huge influence on judges. Very huge influence. Even earlier, electronic media was having an influence on judges. Social media undoubtedly has a very huge influence on judges. They're reading all these law sites, bar and bench, live law. The minute they say, oh, there's a huge outcry in the social media, next day the judge will either apologize, expunge remarks. This is thing happening. But what we're not noticing is what's happening in the trial courts. Many judges in the trial courts have told us, that their work is actually getting affected. A witness is in the box. And suddenly, you have a large number of messages concerning or even video clips or opinions on that witness float through on WhatsApp messages. And so some judges actually asked me in the High Court in Orissa, what are we supposed to do? I said, of course, switch off your phone. Don't see your phone at all. But it is true, social media is having a huge impact on the way judges work. Judges to watch out. See, despite all this, there is one judge in UP who says, why should I accept the government's application for dropping the cases against the murderers of a clerk? It gives you hope, saying here is a judge who understands his or her role so well in the judiciary. This is what the judiciary is meant for. Corruption is an issue. There's no doubt at all about it. But, it's the parliamentarians themselves who are not actually picking up those threads. Yashwant Verma's case is getting picked up, and Ramesh Yadav's case is not getting picked up. And it's a very complicated system that we have. Every time an attempt has been made through Parliament to bring about a law for greater accountability among judges, that law is not passed. So we again have to ask our own parliamentarians, why don't they do that which they're expected to do? So this is definitely a problem. Reforms, 2 or 3 things that I would suggest. On transparency in the Orissa High Court, we actually started bringing out annual reports which explain the problems that the institution is facing, not just the performance of the institution. So if you look at those annual reports for 2021, 22, and 23, you'll find a different model of reporting back to the public. Statistics on how courts work has been halted for a variety of reasons, and how the court is not getting support in certain instances. Second reform is petty cases in the court. You know, somebody who's carried a load of 10 kgs of firewood is facing prosecution under the Forest Act, who's a tribal. And there are thousands and thousands, and when I say thousands, I mean 20,000, 30,000 cases for something that's happened from 15 years ago, and that's filling up the court's dockets. If you really analyze the court's dockets, you'll be able to sift out the serious from the non-serious cases. There are ways of closing the non-serious cases, like, you know, somebody carrying 5 liters of alcohol and therefore violating the Excise Act of a law. So, yeah, we've run out of time. So there are ways of, you know, improving the functioning of courts within the existing framework with the existing resources.
If there are questions remaining, you perhaps can find some time with Justice Muralidhar. Thank you so much for this conversation and being so frank and forthright. Thank you so much, and back to you.